adopt the rules and go from there.
They said we need a majority for the rules. To vote on rules, I don't know if you.
Good afternoon. I'm sorry for the delay. There's been quite a few things happening at one time, so I apologize for you having to wait. But I would like to ask someone, maybe Representative Leverett, if he would open us in prayer, especially for Chairman Tyler Paul and his wife. 14.
Stand.
There we go.
Is it on? There we go. Thank you, Madam Chair. If you'll pray with me, please. Heavenly Father, thank you for this day. Thank you for another chance to enjoy your creation. We ask that you be with Tyler, Paul, and Shannon as they have a new addition to their family imminently about to arrive. And please look over them and make sure that everything works out for them well, and give them strength and energy as they embark on the path of being new parents. We ask that you please look over our deliberations today, make sure that everything we do is wise and just in your sight. And we ask this in your name. Amen.
Thank you so much. Before we get started hearing bills, we do need to pass our non-civil Judiciary Committee rules, which hopefully is in your folder. I don't know if anybody's had an opportunity to look at that. So is there any discussion or questions? If not, do I hear a motion? There's been a motion and a second, so by acclamation, all those in favor?
Aye.
Opposed? Then the rules are passed. Thank you very much. This afternoon, we are going to do just a hearing only on two bills, and we're going to start with House Bill 123, presented by Representative Werkheiser. And just a note of caution, we do have a number of members we have GDOT elections this afternoon simultaneously in the Senate chamber going on. So we are going to have a hard stop this afternoon, unfortunately, at 3:40. So if you can combine other people's remarks or limit your remarks, I would appreciate it. Thank you. Representative.
Madam Chair, I'm here to present House Bill 123, appropriately named as 123. Wisdom, moderation, and justice. So, individual that's in this room, Kathy Harmon, brought to the Speaker's attention an item that is kind of unique to this state, and that is that we execute those with intellectual disability, and pretty much the only state in the country that does this because of a couple of reasons that we seek to change in this bill. And I'm going to do this a little differently because I know there's plenty of lawyers in this bill, in this room that are chomping at the bit to speak. So I'm going to give you the non-lawyer version of what this bill does. It does two things. Let me preface it by saying in 2002, the U.S. Supreme Court, in a matter versus Virginia, said that it was violated the 8th Amendment to the Constitution to execute someone with ID because it was cruel and just unusual punishment. But yet, since then, we have done that more than once. One such instance was in 2015 when it was unanimous between the defense and the prosecution that the person had intellectual disability. It rose to the level of Supreme Court, as all capital cases do. And one of the justices said, until the legislature fixes this, we have no choice. And so they did execute that individual. And I believe it is incumbent upon the state to protect those who cannot protect themselves. So the bill does two things in its current state. It changes the standard of proof from beyond reasonable doubt to a preponderance of evidence. Again, this is what every other state that practices capital punishment does. The second thing that the bill does is it determines the issue of intellectual disability before the case in a separate hearing before the trial. And the reason for that is capital punishment cases are very long and usually very gruesome. And so after hearing weeks of testimony and seeing images that most people wish to unsee, then there's a bias there. And so then the determination is whether that person has ID or not, when in reality, either you have ID or you don't. And so the argument is made that if you had that hearing at the beginning of the trial as to whether someone had ID or not, and then you did the case. I do want to emphasize one thing, because early on in some discussions, it does not open the avenue for anybody who is currently on death row, and so it would not open the floodgates there. It would be just on cases moving forward. I know that's brief on a very complicated bill, but that's what the bill seeks to do.
Any questions for the representative? If not, I'm sure we have a number of witnesses that would like to come up. And we do not have a sign-up sheet. Does anybody have a sign-up sheet? Okay. Okay, great, amazing. Thank you. Thank you. Thank you for.
You're hiring.
No, thank you for pinch hitting.
Some days I might be willing to swap. I know that Chairman, hello, Maisie Lynn Burton from the Georgia Association of Criminal Defense Lawyers. It's really good to see you this year. I know Chairman Werkheiser has a lawyer with him from the Southern Center who could deal with some more meaty issues for you if you'd like, but I just want to let you all know that GACTL certainly supports this bill as drafted. In the Young case, which is a Georgia Supreme Court case here, the court signaled a need to address Georgia's standard of proof. We are an outlier nationwide. Georgia is the only person who requires proof beyond a reasonable doubt that a person is living with intellectual disability. Georgia is also an outlier in asking jurors to consider whether a person lives with intellectual disability at the same time they're determining whether she committed a very terrible murder. The conflation of these issues is not only confusing, it's prejudicial, and it's just as burdened as the standard of proof is. It's irrational to be concerned about the standard of proof and not also to be concerned about the procedure. Both of these need to be changed in Georgia, and House Bill 123 offers a reasonable means to address both, while also bringing a more fiscal soundness and efficiency to the very few cases where an intellectual disability claim would exist in the death penalty context. That's all I have to say, unless you have questions. I'll let the others come on up.
Thank
Thank
you.
you.
Thank you for your testimony. Let's see, Wright Barksdale.
I'll be joined by Sheila Ross with the prosecuting attorney.
Thank you.
My name is Wright Barksdale. I'm the district attorney for the Okmulgee Judicial Circuit, and I had unfortunately had the opportunity to prosecute the two most recent death penalty cases. I was the district attorney that prosecuted the two individuals responsible for murdering two correctional officers during a prison escape. The shooter of that horrendous crime spree was an individual by the name of Ricky Dubose, and it was the first death sentence obtained in this state for a number of years. My stats showed that in 1999 there were 128 people on death row. Currently there are 34 people on death row. Since 2011 there have been 5 death sentences rendered in the state. I want to be clear, nobody with intellectual disabilities has been put to death in the state of Georgia. Nobody. The bill as it is currently drafted, after having meaningful and fruitful conversation with Mr. Werkheiser, the district attorneys are willing to agree to have the standard of proof changed. We recognize that there are a number of states that have a different standard than what we currently have. However, understand this, the procedural changes to this bill would all but kill the death penalty in the state. And if that's something that you want to do, my job as district attorney is to follow the law and follow the evidence. If you want to do away with it, do away with it. But if you don't, this bill would, for all intents and purposes, kill it. And let me tell you why. First, the pretrial hearing that would be determined by a judge, depending on what area of the state that you are in, the case would never get past the judge. If the judge rules against the defense, more than likely it will be appealed. On average, a death penalty case takes about 5 years to complete. If there's an extra appellate process or step in there, we're looking at 8 years down the road, more than likely, which would be detrimental to the state's case. After the pretrial hearing, you would add an additional step in the trial process. You would have, first, as I understand it, the guilty not guilty phase. Then you would have a separate phase that we do not currently have, which would determine whether or not an individual is intellectually disabled. And then the sentencing phase, where mitigation and aggravation would be presented. So what I'm telling you is that the district attorneys are willing to get on board with changing the standard of proof, but we're adamantly opposed to the procedural changes. And when I say the procedural changes, we are adamantly opposed to everything in this bill but the standard of proof being changed.
All right. I appreciate that. Did you have any further remarks? I think you have a couple of questions from number 5. Okay, Darshan.
Thank you, Madam Chairwoman. So to be clear, you said that this would kill the death penalty. I guess I interpreted it differently. It seems like it may slow down the process, but it would not get rid of the death penalty. Is that, I mean, tell me, what am I missing? What
I will tell you, at the risk of maybe offending people, my experience, and I will speak to my experience, the capital defenders tried to claim that Ricky Dubose was intellectually disabled. Okay? Ricky Dubose, while he was awaiting his trial, was found in possession of a homemade handcuff key that worked. He was found in possession of methamphetamine. He was found in possession of 11 cell phones hidden in his door. He was found in possession of wrenches that could manipulate the doors and the toilets and other items in that cell. He was able to set fire to his cell. He was able to communicate with the outside world while being housed at the special management unit. But yet, they were able to go and talk about his school records from when he was in elementary school to try to make an argument that he was intellectually disabled. Although some of this is very well intended, it would be abused in the name of trying to save an individual's life. And I can respect a position that some of the people in this room have with their views for the death penalty. But as long as the laws in this state are that we are to have the death penalty, what I'm asking from you guys as a body is, if that's your intention, then make it a viable option. If not, do away with it.
Can I just come in and say I still don't get your argument that it totally eliminates the death penalty. Does it slow down the process? Yes. But to say that it eliminates it, I think is a little extreme for me. But that's my.
Thank you, Representative. Number 7. Representative Panich.
Can you hear me?
Mm-hmm.
It's good
Hi.
to see you. I met you once when I was in law school. You don't remember it, but I do remember you. It's been a while.
It's good
I
to
hope
see
you're
you
well.
too. Thank you. I have been. I do have some questions.
Excellent.
And you know, I come from a criminal defense background,
Yes,
so
ma'am.
I want to ask the leap to say that the death penalty won't exist anymore. I'm also having trouble making that connection. you're saying that an additional pretrial hearing
Yeah.
and an interlocutory appeal is going to crush your case?
So you, as I know, are a very successful attorney. So you know that when we tried our 2 death penalty cases, after the guilty, not guilty phase, defense counsel for both teams went down to my office in Putnam County, Georgia, with 2 hand trucks with banker boxes of information that they were going to use in the sentencing phase that we had never been provided.
That sounds like a discovery problem.
Well, that is part of the law here in the state.
Fine. So let's say we revise the discovery issues. That doesn't affect whether we should have a pretrial hearing or not on the issue of whether somebody is intellectually disabled, right?
I'll defer to Sheila Ross on this.
Good afternoon. I think it's the globally with this bill, it's not just a pretrial proceeding that is the problem. After the pretrial proceeding, if the defendant is not successful in the pretrial proceeding, then we go through a trifurcated trial process, which also can be appealed. And the way that the litigation is currently structured in this bill, there is no exit ramp. Like, the only exit ramp for this litigation is for the defendant to be found intellectually disabled somewhere along that route. Otherwise, it is nonstop, continuous litigation on this one same issue that they have lost over and over again. So play it out all the way through. Let's say a person claims that they are intellectually disabled at trial, Ricky DuBose, under this current bill. He will first have, if he wants, a pretrial proceeding with the judge, where the judge could end it right there, and if the judge ends it, then we have a chance to appeal. They have a chance to appeal if the judge doesn't end it. Let's say the judge does not end it. Then we go to a trifurcated proceeding. So in the first stage of the proceeding, it's something you're very familiar with. Are you guilty or are you not guilty? Done. Then there's a third proceeding. Are you intellectually disabled? Are you not intellectually disabled?
That's the second proceeding.
That's second proceeding.
Okay.
And if you're found to be intellectually disabled, you're off the exit ramp. We're done. We're done.
We're done in that, just to be clear, the person could be sentenced to life.
With the possibility of parole, not LWOP, as this is currently structured, yes, life with the possibility of
Right.
parole.
It's not.
Right.
Okay.
That's
going.
if they win in that stage. If
Right.
they don't win, they lose that stage. Then we go to the sentencing phase of the trial, where the jury will be given 3 options: life with the possibility of parole, life without the possibility of parole, or the death penalty. And the jury will decide, and they'll be told you can give him life for any reason or no reason at all. And in that third proceeding, they again can raise the issue of intellectual disability. So this is now, we're still litigating the same issue that you've lost before the judge, you've lost before the jury, but you can still tell the jury, look, I know you didn't find him to be intellectually disabled, but you can use this as mitigation to spare his life. And let's say they still give him the death penalty. Then we go through 30 years of state and federal habeas, where we are again litigating the exact same issue, which is intellectual disability. So the issue with the procedure, and as Mr. or DA Barksdale said, it's not the standard of proof that anyone has an issue with. Change the standard of proof. It is this pre-trial hearing with a trifurcated proceeding that has no exit ramp unless the defendant is found intellectually disabled, where they can litigate the same issue over and over and over again. And where else do we do that in criminal law?
So as my colleague said, it sounds like it slows it down, and it sounds like the challenges you're having are really with the habeas process or the appellate remedies, not with that having a pretrial determination of intellectual disability. And presumably, if the person meets their burden, that's one less person that we have to deal with for appeals for 30 years, which are going to happen in any death penalty case. We're going to have appeals for the next portion of years until it's finally resolved. And it never resolves because, frankly, until the moment of execution, somebody can call it off, whether it's our courts or the Supreme Court. So
the pretrial determination, though, which would not be, the state does not have to consent to, would take the matter out of the hands of the people. It would put it in the hands of a judge.
an elected judge.
Still takes it out of the jury's hands. It takes it away from the people. So that's a way for it to disappear. And I think that's what Mr. D.A. Barksdale was talking about, depending on certain judges. It'll encourage judge shopping. It'll end it there for now and forever.
Okay, I think you're jumping into judge shopping. I think you're jumping into things that are not there. But
You don't think that happens?
I don't think it happens the way you think it happens. I mean, I don't know. I know that there are rounds of, all the courts I practice in, you can't select the judge you're going in front of. You may get lucky and end up with the judge you want, but that's not something that you can choose to do. We do pretrial hearings for immunity. We do it for motions to suppress. You can lose a motion to suppress and still go to trial and argue the same thing in front of the jury. I mean, I'm not understanding how this is any different from any other pretrial proceeding that might delay an ultimate resolution or an ultimate adjudication, but it doesn't. But now we're dealing with the death penalty. And so I'm okay taking those extra steps to make sure that if you're going to impose the death penalty, that it's for the right circumstances. So I'm just concerned. I appreciate what you do. I appreciate your service to the state. I know sometimes we're on opposite sides, but on this, I mean, we're trying to get to the same goal, which is justice for the people of Georgia. And I want to make sure if we're going to execute somebody, that it's not somebody who's intellectually disabled, which is why I assume you're okay with the standard of proof being lower.
Right. Yeah, we don't want to execute intellectually disabled people either. And a lot of times I hear the other side say, well, that no one's ever been found to be intellectually disabled. And that's because we plead those cases. When it is close, when there is an issue, we allow those defendants to plead a life without parole. And I know lots of people in this room have participated in those plea negotiations.
And that's you, and that may be you. That may not be every prosecutor in Georgia.
Well,
What I will tell you is this. As a district attorney, I'm telling you, as somebody that has gone through 2 death penalty cases in the modern era, that this procedural change will all but kill it. And we can certainly, I respect you. I
No,
do.
I appreciate that.
But I'm telling you, in my humble opinion, in my experience, based on what I've said and what Ms. Ross has said, in practice, in real practice, it will do away with it. And we're already seeing a drastic decrease. I myself have withdrawn 2 death notices. I've got 8 counties. I've got no death penalties pending. I withdrew 2 recently.
For what, under what circumstances?
I was
I'm sorry.
in a
So
Sorry.
we're starting to
Madam
derail a little
Chair.
bit. We've got a couple more questions. If
Sure.
you don't mind, I'm going to move on. Number 14.
Thank you, Madam
Mr. Chairman.
So I don't practice criminal law. As I have said before, the breadth and the scope of the criminal advice I can give people is best summed up by the words of the Willie Nelson song "Me and Paul" when he says, "Almost busted in Laredo, but for reasons I'd rather not disclose. But if you're staying in a motel there and leave, don't leave nothing with your clothes." That's about the extent of what I know about criminal law. But I will say I'm trying to sort of unpack the objection to the changes here, and is it the sort of is it the fact that the defendant gets continued bites at the apple that you find to be most objectionable? Because it looks to me like if you lose on intellectual disability, for lack of a crass way to phrase it, I know, but if you lose on that issue, the defendant keeps raising it. If he loses, I'm sorry, other way around. If you lose, it's done. If he loses, he gets to keep raising it. One question I have is, would there be a constitutional limitation? And this is a question I would ask folks who are, advocate for the bill, with changing that provision so that if at the pretrial hearing that issue is decided adversely to the defendant, it cannot be raised any further.
well, that's how they do it in California and in the federal system. So
They have a pretrial hearing and that ends it.
and you waive a jury issue. And here that's not the case. You can have a judge, then you have a jury, then you have mitigation, and it just keeps going. And know that anyone can raise intellectual disability as a defense to a crime. And in the oral arguments before the United States Supreme Court on this issue on a Texas case, I mean, they even surmised or opined that, a NASA scientist can be intellectually disabled. So we're worried about it opening up the class of everybody who's going to start now once they file the few capital notices that they do file, that now we're going to be litigating this in every case that we have.
Well, and it sounds like you'd be litigating it repeatedly with every
Correct.
case you have.
Correct.
So, in response to my question, did you indicate you felt there would be a constitutional problem with restricting the defendant to raising at one time in this non-jury proceeding?
I don't think there would be, because the federal system has been upheld to be lawful and constitutional.
And that's how it happens in the federal
Right.
system.
And in the California, they do it that
So
way.
they
as
have a
well.
pretrial hearing before the judge, and when that issue is decided, if he decides there is not an intellectual disability, then that can't be raised at sentencing or.
Well, I think they can always raise it in mitigation, and I think that's the fair thing to do. I think you should always be able to raise anything in mitigation, but you substitute the fact finder at that stage. So if you opt for a pretrial determination with a judge, then the judge is the fact finder, the final fact finder on whether you are in fact intellectually disabled or not. Then you cannot then raise that very same issue with a separate fact finder and see if you do a better job and see if you get a different result. I think you should always be able to raise intellectual disability, mental illness, anything you want to raise in mitigation, and I don't think we should ever
But
stop
it's only
that.
for purposes of mitigation at
Right,
that
where
point.
when the jury is deciding what they should do to you, I think you should raise whatever you want to raise.
And I think the other thing that yes, the procedural piece with the multiple bites of the apple. But understand this: the way this thing is currently laid out, if they're found intellectually disabled, they can't even get life without the possibility of parole. So I want to give you that scenario of somebody that drives a car and through a crowd of people and kills 10, 15 people. If they're found ID, the worst that can happen is life with the possibility of parole. What this bill is, because somebody may come in behind me, and I want to make sure that this is clear too. This bill has been touted as the procedural pieces. Everybody else has got this. A lot of the states have the standard of proof, but the procedural steps, they basically cherry-picked from all over the United States, and this is some type of super bill, basically, that takes the strongest points of different states.
From a defense perspective, and
Yes.
puts them in one place.
Correct.
So, I guess what I think some of the questioners that you've faced before, and what I'm curious of is there a way? Right now, I gather the way it happens is you have a trial, and at that trial, simultaneously you are trying the issue of the defendant's intellectual disability and guilt or innocence of committing the crime.
Right, so the jury is given 5 options as it presently. It's a bifurcated proceeding, so the first proceeding is guilt innocence, the second proceeding is sentencing. At the first proceeding, in the bifurcated proceeding, the jury's given 5 options: guilty, not guilty, not guilty by reason of insanity, not guilty by reason of intellectual disability, guilty but with intellectual disability, and guilty but mentally ill. So those are the 5 options that they're given. And sometimes insanity and mentally ill are not even a factor, just depending on what the evidence is. So what it would normally work out to be is 3 options: guilty, not guilty, or guilty but with intellectual disability. So it's all litigated in that first stage of the proceeding. And then you go to a sentencing trial if the defendant is found guilty. If he's found not guilty, obviously you don't go to a sentencing phase.
And then, depending on the particular option the jury picked, that would determine the scope of possible penalties.
Correct, because if they find them guilty but with intellectual disability, then the only
It's no longer a capital case.
It's life.
It's not- yeah, it's not
over.
capital, okay.
It's over, but there's no pretrial proceeding. There's no pretrial proceeding.
Right, it's all
just that
done.
one proceeding. Yes, it's a one proceeding in front of the same fact finder.
And I'm sorry, there was one other question from what you were saying there. I can't think of it now. But so I guess I'm just trying to probe what you think would be workable. I gather you have a concern about submitting the finding on intellectual disability to a judge rather than keeping that with the jury where it's traditionally been.
What I will say is this: at this particular point, what we can agree to is changing the standard of proof. And the reason why I wanted to give you these numbers: 128 people on death row in 1999, 34 now, 5 death sentences in almost 15 years. This narrative that's being pushed is just not true. In fact, the stats and numbers that you can't run from is the state of Georgia and the district attorneys are being very selective when they seek death, and they're seeking it less and less and less. And then even when they do seek it, they're unsuccessful, I would say, the majority of the time.
Just one other question. You just reminded me of the question I want to ask. Thank you. So right now, if I'm a criminal defendant, we are trying all that at one time, and I have the burden of proving the defense of intellectual disability, and I have to prove that by the same burden you have, beyond a reasonable doubt?
Correct.
Okay.
And that right now is happening in the first phase of the trial. And so the jury could say, hey, he's guilty, but he's ID. And if that happens, it stops right there. If not, then under the current system, it goes to phase 2, which is the aggravation and mitigation portion, and everything is mitigating.
So did you say that the trial is conducted where guilt and innocence and presence of an intellectual disability are determined at one, that's just one set of witnesses, one set of testimony?
So their verdict form would read guilty but ID, not guilty, something to that effect.
And so you don't object to changing the standard, but I gather you do object to the pretrial.
We object to all of the pretrial changes, every one of them.
And I think you're also saying there's some changes in sentencing options in this bill as well.
Correct. If you read the bill, it'll talk about if somebody is ID, they've taken it a step further, and they're even taking life without the possibility of parole off the table.
Okay. Thank you, Madam Chairman. That was a lot of questions, so I appreciate it.
Thank you. I appreciate your testimony. Any additional questions from the committee? Oh, I'm sorry.
Same mic.
Mr. Chairman, by all means.
He's already warmed it up for me, so that's good. I was a DA at one time and had the unfortunate experiences of declaring 4 death penalties and trying 2 of them. But none of them had these issues in it. So this is somewhat new to me, and I've forgotten a lot of what I used to know back then about this kind of stuff. In looking over this, and you're talking about all the pretrial stuff, Section 1, lines 16 through 34, if they were deleted, would that take care of most of what you're talking about?
Lines 16 through 34? No, sir, it would not.
What else do you have that you're concerned about?
On page 5, 108 through 125.
So could strike all that. Yeah, it's got to change the standard. What's wrong with 108 through 125?
108 through 125, as I understand it, is the procedural step once the trial starts.
It's the trifurcation.
What that does is it takes a 2-phase death penalty and makes it a 3.
I see what you're saying. Yeah, okay.
Yeah.
Yeah, I'll give it up to you.
If I may,
Yes, of
the
course.
change in the standard is in lines 25 through 28, is it not? There's some other stuff in there that I know where it says you get a second bite at the apple, and
Really?
it puts the burden of persuasion and production on the defendant to prove intellectual disability by a preponderance of evidence. But then after that, it kind of it has sort of there's no issue preclusion if it's adverse to the defendant.
What we would want is basically to take this and take the current law and just essentially take where it says in our current law that they've got to prove beyond a reasonable doubt, take that out and just put preponderance.
Preponderance.
That's what we're asking for.
Is that
It's in the current 17.7.131.
Okay.
Right.
So
We're just going to stop it.
So if you look,
So unfortunately, I think we're out of time for those that have to participate in the GDOT election this afternoon, but I certainly appreciate everyone coming. I'm sure we're going to have further discussion on this. It would encourage y'all to get together with the author and Chairman Gunner and Chairman Leverett. And
Thank you very
talk about
much.
this.
It's a
So
pleasure being here.
Thank you so much. I really appreciate it. We adjourn for this afternoon.